So, when creating an estate plan, the first step that we have is we have a free initial consultation. And during that initial consultation, the purpose of it is to learn about our clients, learn what their intent is in creating the estate plan, and gather as much information as possible from them so that when we create their trust, we do so to meet their ultimate goals and needs. It's important to speak with an experienced attorney instead of a legal Zoom. And the reason I mention that, I once had a client come in who had created an estate plan through LegalZoom, and her husband just died. She handed the portfolio over to me that LegalZoom had created, opened it up, and her husband never signed the will. So it can be something as simple as that. It's important to have an experienced attorney because they're going to cross all the T's and dot all their I's to make sure that the plan is not only properly prepared and customized to meet the client's needs, but also that it's executed properly. So when it needs to be carried out, there's not going to be any issues or delays in carrying out the plan. A testamentary trust is a trust that's created within a will. So, in order for that trust to become effective, that will would need to be submitted to probate, and then the trust would be created through the probate proceeding. The reason why we don't recommend testamentary trusts or prepare them too often is because you could avoid the probate proceeding if you just created a revocable living trust to leave assets to your loved ones and heirs. With that, a revocable living trust is a trust that's created during the lifetime of what we call the trust maker, and it is funded with the property of the trust maker. The trust maker is also the trustee and the beneficiary, and by revocable, that means that the trust maker has the ability to amend or terminate the trust during the trust maker's lifetime. So it doesn't become effective and irrevocable until the trust maker ultimately dies. Now, once that revocable trust is created and funded, the property can be used for the benefit of the trust maker. So if the trust maker becomes incapacitated, whoever is listed in that document as the successor trustee can use the assets of the trust to take care of the trust maker's bills and expenses with a much smoother transition than having to rely on a power of attorney, or in the worst case scenario, if there's no power of attorney, then it would have to go through a conservatorship proceeding with the court. There's also a number of other terms that you hear commonly referred to as a revocable living trust. You might hear living trust, inter vivos trust. Those are all one and the same thing. A trust is a means to create a plan to have people take care of your expenses while you're still living. And then additionally, a trust is used to transfer assets when you die without having those assets go through probate. So it provides those two primary benefits: incapacity planning and smooth, orderly transfer of assets at death. Maintaining a trust really comes down to changes in your life. So anytime there is a major change in your life, for example, maybe you have another child, maybe a successor trustee in that document dies, then you need to review the terms of your trust to make sure that it still suits your needs, or if it doesn't, it would need to be amended to comply with those major changes that just occurred in your life. A trust is not something that gets filed or administered by the state. It's a private document, and that's one of the benefits in creating it, is you can keep your affairs private and not have to worry about filing reports with the state, with the court, whatever the case may be. So it provides a level of privacy for the person who creates it. A trust administration is the proceeding that occurs after the death of the trust maker. So when the trust maker dies, a successor trustee is appointed to carry out the terms of the trust agreement. So there would be a period of time where that successor trustee would pay off the final debts and obligations of the deceased trust maker. And then ultimately, when that's finished, they would distribute the assets to the beneficiaries. Now, they could distribute those assets outright. The trust may call for the establishment of several subtrusts that require further administration. For example, if you had a beneficiary that was a minor, that minor is not legally capable of managing properties. So then that successor trustee would take care of that money for that minor. They could use that money to pay for education expenses, living expenses, healthcare expenses until the minor reaches a certain age. And that would be an age that the trust maker would set forth in the trust agreement. They would set an age at which point in time their minor child would be responsible enough to assume the responsibilities of a successor trustee or to receive that money outright. If you have any questions about wills or trusts, you can call me at any time and I'm happy to answer your questions. We don't charge for an initial consultation, and I look forward to hearing from you.